Karen Reed was a college professor dating a Boston police officer named John O'Keefe. Outside of her friends, family, and students, no one really knew much about her. But that anonymity changed one snowy night in Canton, Massachusetts. After she and John went bar hopping downtown, Karen drove them to the home of another Boston police officer. He had invited a bunch of folks over to his house for a little after-hours party before the blizzard was supposed to roll in through town. John O'Keefe died that night, and everyone agrees it was a homicide. But the question is, who is responsible? And the answer depends upon who you ask. The prosecutor says John never made it inside the home because Karen purposely backed over him with her SUV and left him lying in the cold on the front yard to die. Karen says John did go inside to that party, and she went back to John's house. She also believes it was someone inside the house who killed John and then put him on the front yard to frame her. After more than 9 weeks, more than 70 witnesses, the question is, what will this jury say? Tonight, we have the latest from the courthouse as we continue our investigation into the tragic death of Officer John O'Keefe.
I'm Vinny Politan. Thank you for joining us tonight here on Closing Arguments. Wow, here we are on Friday. A lot of expectations going into the day, and a lot happened today. But we're still not there. This, I think we can all agree, is an unusual case. Very unusual case for many reasons. Part of it begins with everything that has happened outside of the courtroom. Extremely unusual for a case of, it's a murder involving two people who knew each other, two people who were a couple. Those are the allegations. And in cases like that, you generally don't get public reaction to this extent, especially public reaction supporting the accused killer. And from the beginning, I knew this is what set this case apart from the rest. And as a result of this public reaction outside the courthouse and in the community and all over social media, you've created a very intense situation at the courthouse. Extremely intense. Much more intense than you would expect for a case of this nature. But that's where we are. That's where we are in the Karen Reed murder trial. The death of John O'Keefe, a Boston police officer. So I also think that we can agree this is a tough case. And I say that for a couple reasons. One, two completely different versions. You've got Karen Reed accused of admitting to this, and then you've got a lead investigator who had to admit to a lot of problems with some of the things he was saying and some of the things he was allegedly doing in this case. So the key to the defense, the defendant, the key to the prosecution, the lead investigator, and both have issues depending upon what you believe and who you believe and how they testified in this case. So here we are, and here's the jury, apparently deadlocked at this moment. Unable, after Tuesday, Wednesday, Thursday, and Friday, to reach a verdict, and they actually spoke to the jury through their note today. It was a big moment. I don't know if we expected it or didn't expect it. I don't know. I never know what 12 strangers that I never met are going to do when they get inside a room and try to figure out a 9-week trial. But here's what happened when they sent the note out to the judge.
We're back on the record on 22-117, the Commonwealth versus Karen Reed.
Okay. All right, so counsel, you're aware of our note from the jury. Dear Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict, signed by the foreperson. So I want to hear from counsel your view on whether there has been due and thorough deliberation. So let's start with the Commonwealth.
My answer would be no, Your Honor. This simply hasn't been sufficient time yet.
And what does the defense say?
We believe that there has been sufficient.
All right, so I'll hear from both of you in more detail. Mr. Lally, I will hear you.
Your Honor, the jury received this case just earlier this week. They've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted their due diligence in regard to their deliberative process, but I would submit that it is far, far, far too early in their deliberative process to even consider giving them any kind of Tui-Rodriguez instruction or anything close to that. Furthermore, what the note doesn't really indicate affirmatively that they can't come to a conclusion. It just says that they haven't come to a conclusion through their deliberative process at this time. They're not even asking for one, is what I would say.
All right, thank you. Ms. Giannetti, I'll hear you.
Your Honor, I would disagree with Mr. Lally's characterization of the note. The word exhaustive is the word I think that's operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they're at an impasse. This is a case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report that they were not allowed to get. And I think the message has been received that the evidence is closed. They won't get anything more. They've been working essentially nonstop over the last 3-4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the Tui-Rodriguez model instruction and go from there.
Okay. All right, so you all know that it is within my discretion, I decide. So a case that has been, it's a long case. This is our 4th day of deliberations, but Tuesday was a short afternoon, maybe 2.5 hours. Wednesday, they left early because of an appointment. Yesterday was also shortened a little bit, and this note arrived with less than 3 hours of deliberations today. So the length of the trial, the length of the deliberations, I know the case we heard from 74 witnesses. There are 657 exhibits, very complex issues in this case. I'm not prepared to find that there have been due and thorough deliberations at this point. So I am going to send them back out. We'll bring them in and we'll do that now.
All right, to the court, please. Jurors entering.
Right, so jurors, I'm in receipt of your note. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict signed by your foreperson. We all know how hard you've been working. Lunch will be arriving shortly. When it comes, I'd ask you to clear your heads, have lunch, and begin your deliberations again. Or continue your deliberations, all right? So I'm sending you back out.
Wow. All right, let's bring in Court TV crime and justice correspondent Matt Johnson, joining us live from outside the courthouse in Dedham, Massachusetts. Matt, wow, what a big moment there. The jury's working hard, obviously didn't come to agreement. They're trying to. They felt that they couldn't, but they went back to work. Tell us about deliberations today.
Hey, Vinny, that was a big moment here in Dedham. I mean, everyone's on pins and needles at the courthouse here after these 9 weeks. And you heard Judge Cannoni right there just how intense this case has been and how much evidence they have to go through. So the 6 men, 6 women on the jury after 4 days of deliberation, still no verdict, and they're being required to come back next week. Well, the day started out with what appeared to be confidence on both sides. You had Karen Reed arriving with her entourage today. Now she has security detail that are volunteers along with her family and those state police officers that lead her to the entrance of the courthouse. They looked very confident today after telling our crew yesterday that they felt good after a third day of deliberations with no verdict. We also saw the O'Keefe family present today, and we saw them in full force, including John O'Keefe Sr. and Peggy O'Keefe. They all didn't attend every single day of testimony, so it was big to see everybody from the family in attendance today for part of the day. But at the end of the day, as you know, the jury was sent home. They were unable to reach a verdict, and here's that moment.
So, jurors, we all know how hard you've been working. It's been a long day. We're going to let you go home. We'll see you Monday morning at 9 o'clock. To the extent that you can, please just not think about this case this weekend. Clear your heads. We'll start fresh another Monday.
And Karen Reed and her attorneys no longer answering questions of the press as they leave the courthouse. They haven't answered anyone's questions, really, since the start of deliberations. So that's a big change as well with what we're seeing with this defendant and this defense team.
All right, let's talk about another part of this case, another part of this trial, another part of this story, and that is the scene outside the courthouse. What was that like today?
Yeah, it's been fluctuating, Vinny, because on the day of closing arguments on Tuesday and those first couple hours of deliberations, we were seeing upwards of 400 supporters across the street in that buffer zone where they have to maintain and be away from the courthouse entrance. Well, it's been fluctuating over the past couple days. Again, today is day 4 of deliberations. Today, they were still strong and out in force, and they were also rallying each other. Take a listen.
Scientific evidence, by the way, that came from people that are hired by the Department of Justice and the FBI, and guess what? The United States military. If there is someone on that jury that denies that irrefutable evidence, we got a problem. And we will address that. Let them go.
And that pretty much happens all day. This crowd gets fired up, and they also cheer every time Karen Reed walks by. But there was a big moment today for this, for these supporters, because they were met by anti-Karen Reed protesters. The very first time that our cameras have caught anti-Karen Reed protesters. They were holding signs of their own. They were also very vocal. Take a listen.
Karen Reed is guilty, and there needs to be justice for her. This is wrong on so many levels. The family has been harassed relentlessly, including yesterday, even when these circus animals went down there to harass the O'Keefe family. Have some respect. A man has died. He has lost his life, and those children lost 3 adults that took care of them.
Now, Vinny, there's a lot of things that we read online, and I want to dispel a lot of myths just in case there's anything written about the interaction here. Yeah, they were shouting with each other across the street and in person, but no one was violent during these interactions that I witnessed. And also, these Karen Reed protesters, they were saying that there's actually a lot more of them. But there was only about 5 or 6 that showed up at the courthouse here today because they say a lot of people are concerned or worried to view that opinion. It really shows that this community is divided.
Yeah, interesting to see for the first time during this entire case, like from pre-trial to trial to now, that we're seeing folks from the other side, anti-Karen Reed, believes she should be convicted, believes that she should go to prison. Okay, let's talk about Karen Reed a little bit. You know, this is a big development in the case when a jury comes back and says, you know, we're deadlocked, we're at an impasse. What was her demeanor like today?
Her demeanor started off very confident when she was walking in on the courthouse steps with her attorneys by her side. She was in court. I was looking at her. She was, you know, smiling with her family members in court. You can see, you know, She's very confident right there, by all accounts. And she has been throughout this whole trial, but she's also been very hands-on with her defense team. When I've been in court during the testimony, during the 9 weeks, she's writing Post-it notes, she's going through those evidence books, she's also passing notes and talking to her attorneys. She was very active. But now that all the evidence is in, and her fate is within these 12 people that are going to decide whether or not she's behind bars and convicted or she goes free, she's a lot more serious. And inside the courthouse here behind me, I see her huddled with her attorneys. And then I also see her behind in other rooms where she's praying with her family. So it's all become very real for Karen Read.
All right, Matt Johnson working hard again all day today, all week, 9 weeks. I guess now it's really 10 weeks, right? So, Matt, enjoy the weekend, but we'll see you again on Monday. Thanks so much.
Thank you.
Now I want to bring in a special guest, one of the lawyers who represented Johnny Depp in his defamation case and a partner of Brown Rudnick, LLP. Wayne Dennison is back with us. Wayne, great to see you. I want to get your take on what's happening here, because you were at another court TV trial that we covered, again with our cameras, but it was a big scene in that case outside of the courthouse. So I want to take a look at both scenes kind of next to one another and then get your take on all of it. So let's put that up on the screen if we can. So you can see the different scenes on the left and on the right. Obviously the scene at Johnny Depp, a little different. Obviously people there on the one hand to support someone who's a public celebrity. Here, on the other hand, people supporting someone who was never a celebrity, who they didn't know before all of this. How would you characterize the similarities and the differences between what happened in Virginia and what's happening up in Massachusetts in terms of the public reaction and the public scene outside of the courthouses?
Well, I think the public scene outside the courthouses are similar in some ways, although quite frankly, Amber Heard had a few people who were in favor of her position in the Depp trial. And today was the first time that we saw any anti-Karen Read folk. The principal difference here is the trial that I was involved in and the trial that you were at, Vinny, was a trial between two people who were major celebrities, including one of them who's probably the best actor of his generation. This has grown organically through social media, I guess, but the organic growth of the number of people who care about this trial, who actually are in attendance to this trial, I think is incredible.
Now, there's something else that happened today. We saw folks from the other side, people not supporting Karen Read, believe that she should go, and there was actually a moment of confrontation. Let's take a look.
You look insane. You literally look insane. You're getting all the way over there. So you are engaged. Walk away, right? I don't need to walk away, you crazy person. Why do you think she's a terrible person? Because she supports Julia or Justin. Like, we haven't had a verdict yet. So? I know. Why don't we have like an actual pleasant conversation? Like, what is your thoughts? Tell me what your thoughts are. I would love to know because I want to see what you're thinking.
Turtle Boy.
What does he have anything to do with anything? Turtle Boy.
Hey, it's Turtle Boy.
Yeah. Oh yeah, of course. Yeah. I told you what to do. He didn't even know this was fail. His family did nothing. His family did nothing.
So Wayne, what are your thoughts here? And it's different, right? Because at Johnny Depp, Amber Heard, there was no one there for Amber Heard, by the way. There were I think 2 people, maybe 3 in the whole crowd.
Yeah, there weren't very many, and quite frankly, everybody was extremely well behaved. I know that Amber has taken a position that people said horrible things to her. And quite frankly, I never heard that. You know, my sense of it was that there wasn't any confrontation at the Depp trial. There were very few people who were supporting Amber Heard. Quite frankly, we're the last day of deliberations, or maybe we'll get another day of deliberations before the judge decides whether this is a hung jury. And this is the first day that you've seen anti-Karen Read protesters. One would have, I would have assumed you would have seen them before this.
Yeah, exactly. Especially if they believe that she took the life of a police officer. You would also expect perhaps to see some police officers there as well, but we haven't necessarily seen that in this case. Bottom line, Wayne, what do you think the impact is, if anything, on jurors knowing knowing or not knowing necessarily what's going on outside?
Well, irrespective of the fact that there are these zones that we have to keep people into, jurors know what's happening outside the courthouse. They have to park their cars. Quite frankly, I practice in that courthouse quite a lot. The parking lot's across the street. You largely have to go past these protesters, even if you're a juror. So irrespective of whether these people are away from the courthouse, the jurors are aware of them. I'm quite confident that the jurors take their oaths seriously, and they put that out of their deliberations and out of their mind. But it's not a situation where they'd be unaware of what's happening out front.
Wayne Dennison, great to see you on this Friday night. Enjoy the weekend, and perhaps we'll be speaking again next week about, I don't know, maybe a verdict. Thanks so much. All right, folks, when we come back, we've got more to get to in this case. What exactly happens now? The jury has sent out a note. What's going to happen on Monday? We'll bring in our local attorneys to break it down.
They probably want to methodically follow protocol and go through the notes. Do the things that the Canton police should have done up front and the state police should have done up front and follow the protocol.
On the next episode of Accomplice to Murder.
It looked like Virginia and Norman really had a wonderful relationship.
But then greed planted the seeds of a brutal murder.
$1.1 million in benefits to Virginia.
And when she couldn't find a hitman, she decided to use her son, Jason.
She said, no one is going to be getting in the way of me collecting that insurance money, or they'll wind up just like Norm.
Accomplice to Murder with Vinnie Politan. All new episode, Sunday night, 8, 7 Central.
Only on Court TV.
Dear Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict, signed by the foreperson. We all know how hard you've been working. Lunch will be arriving shortly. When it comes, I'd ask you to clear your heads, have lunch, and begin your deliberations again. Or continue your deliberations, all right? So I'm sending you back out.
It's really fascinating the way our system of justice works, right? So we bring in 12 strangers who don't know each other anything. Many of them probably have never even seen a trial before. Then, we have them there for 9 weeks. It's a complicated case. It's emotional. It's gut-wrenching. And then we instruct them on the law, and then they try to figure it out. And then after, on the 4th day, they're like, we can't agree. We send a note out, and then the reaction is, go back in there, have some lunch and go back in there. And then we don't tell them what to do. We don't instruct them how to deliberate necessarily. We just tell them, you go there and deliberate, figure it out, right? And then, but they send a note saying, we can't figure it out, but go figure it out. So do they know that they need to send out another note saying they can't figure it out? We don't tell them that. But if they send out another note, what's the judge going to do? Send them back in again? And then another note? When does this end for them? How does it end? When does it deadlock? I need answers. Let's bring in our guests. Former head of the homicide unit in the Norfolk County District Attorney's Office, Attorney Rick Grundy is with us, and criminal defense attorney, college instructor, and author Peter Ellikin. All right, so today we hear them throwing out the old we got to give them the Tui-Rodriguez instruction there. All right, so everyone at home is wondering, what's the Tui-Rodriguez? So, Rick, do you want to go? So what happens if this jury is working again on Monday, and they're like, wait, can we send, and they send another note out to the judge. What are they going to do? They're going to give them the old Tui-Rodriguez? And if so, what is it?
So I believe that at that point in time, she's going to be, based on a law, and I'll defer to Peter on this, but based on a law that they have done put in the time, done a good hard shot at it, and she'll instruct them, Tui-Rodriguez. Tui-Rodriguez says that there is no other jury that is going to have a better option than you to decide this case. You are the people. You can do it. I'm going to send you back out to get together and reach that verdict.
So it's like a pep talk.
The big thing about Tui-Rodriguez. Exactly. Well, and I think it's to dispel any concerns they have, like they're in over their head. You know, we just weren't up to this. Somebody will do a better job. It's to tell them, no, you are the people. You're the team. Let's go. The big thing about Tui-Rodriguez, though, is if they come back after Tui-Rodriguez and say we're still deadlocked, it's out of the judge's hand and it's a mistrial.
So it's like the old ball game,
Tui-Rodriguez.
right, Peter? It's like the old ball game. 1, 2, 3 notes, you're out, right? That's what it's going to take here. Like, we have 12 strangers, and they've got to tell the judge 3 different times that they're deadlocked before we accept them saying that they're deadlocked.
Yeah, the judge wants to make sure they leave no stone unturned. Could you imagine if we had to retry this case again, go back to square one, start all over? So they just want to, they kind of push and prod the jury. And we've seen judges send people back 2 or 3 or 4 times. And
4 times?
It does get ridiculous, and at some point you have to throw in the towel and say they're not going to make a decision. But there is actual case law in Massachusetts that a judge should not be giving that Tui-Rodriguez instruction too premature. You should wait a little while. This case, relatively speaking, is really rather early for a deadlocked jury. I mean, it was a total of like 18 hours, and they came back and said we're deadlocked. Normally it's a week or 2 weeks, and then at that point they say we can't go any further. So the judge is kind of obligated to push them at least one more time, perhaps 2 times. And then at that point, and particularly when the jury will say things like, not only can't we come to a conclusion, but we don't think we're going to be able to come. It's like we are at such, loggerheads that it ain't going to happen.
Well, it's interesting because, Court TV, we cover trials all over the country and in a lot of states. One note does it in some states, and I've seen judges do that. In other ones, if there's a second note, they're never going past the second note. Here, it looks like it's going to take 3 notes from this jury, and it's interesting. We don't tell them that. Like, they don't know. So, like, they're sort of working in the dark to a certain extent. I don't know how fair that is to the jury that we don't tell them this, but I think we don't tell them on purpose because we want them to come to a verdict. So let's think about this now. In this case, with this set of facts, right? Like, I think there's only 2 places you can be. Either you believe she struck him with the car, or you don't believe she struck him with the car, right? I mean, and that's like a fact. Like, if you believe one side of the fact, then you are in on guilt. If you believe the other side, you're in on not guilty. So how does someone even compromise? How could a juror, if it's 2, if it's 3, if it's 1, if it's 4, how on earth could they make their way over to the other side, or where could a compromise be in a case like this? And I'll start with Peter on this one.
Actually, this is Judge Cannoni. A year ago, we had a very well-known case, and that happened. They had a deadlocked jury, and so the mistrial was declared. Then they had a second trial. They retried the case. The jury said they were deadlocked. Judge Cannoni sent them back, and they actually came back and convicted them. So it works some of the time. To me, just the fact that I'm being pushed and prodded and pressured might not do the trick. But what I'm really curious about in this right at this moment, which is the bottom line for me, is we don't know what's going on inside that jury deliberation room. It could be one of 2 things. It could be are 11 people on one side, and there's one person who's unreasonable and just not giving in, and you got to be unanimous, and that's why they're blocked. Or is it, you have 2 reasonable sides, and people are equally divided on each end? So I'm really curious. Is it just, is the jury almost unanimous, or is it really divided? And we will never find that out. And I mean, obviously.
Well, let me tell you something. And Rick, you tell me what the law is and the practice in Massachusetts. But I've been in states where the judge inquires on what the split is. They don't do that in Massachusetts?
That's not going to happen in Massachusetts. No, but I think we will find out at some point in time. A juror will juror's free to speak to the press and let that out. So we'll probably get an idea. But I think it's a very important
What if they
point
put
that
it in the
Peter
note?
makes. We don't
What if they
know.
put it in the note? Will the judge read it out loud if it's put in the note? Will the lawyers find out?
In all likelihood, I would say, knowing that it's being broadcast, you would not read that. Obviously, it would be shared with the attorneys, and they would know that. She may read it, but you know, I was actually a little surprised at the attorney's reaction, because I would have flipped it if I were to guess. The Commonwealth was like, send them back, let them deliberate some more. And the defense was like, nope, end it, drop the curtain, let's go. As I said, I would have guessed it would have been the other way around. The defense was so cocky in their case and seemed so self-assured of themselves. Maybe they just got knocked off and were like, wow, this is not going the way we want to. Let's see if we can get a redo.
What would a retrial look like in this one? Would there be, I mean, generally speaking, we say the retrial, you know, favors the prosecution. Do you think in this case, the retrial will also favor the prosecution, as most cases historically on court TV and I think around the country go when it comes to retrials? Peter?
You know, as I was just bringing up earlier, a lot of it depends, and my mindset will be changed, finding out, is it 11-1 and 11 wanted to quit on, one didn't? And then I'd say that perhaps it would not be that easy a retrial, or maybe they would bring in an entirely new strategy. And certainly, I have a feeling they really need to get rid of that murder charge, because there wasn't even any evidence presented showing that she intentionally, even if you believe the car hit him, nobody knows whether it was intentional or an accident under the worst case scenario there. So I think they might refashion the charges, and they might put together an entirely new and different strategy if they, in fact, do decide to retry the case if it winds up being a mistrial.
How about a deal, Rick? Do you think there would be talks if this was deadlocked? And is there any scenario that the prosecution could offer something where she would not be put into prison, like a home confinement or something?
So the answer to your question is yes, they certainly could. It would defy the facts that they've presented, but it wouldn't be the first time that something along that nature has happened. I think, in my opinion, the prosecution is in a stronger position, agreeing that the prosecution is normally in the better position of the parties in a retrial. I think they're even in a stronger position here because they don't think that they put their best foot forward. I think they likely learned a lot in actually trying this case. And I think the defense is always, particularly in this case where they had so much pretrial publicity, their defense was nothing as it was tried in the papers prior. And I was also shocked to see that this whole dog bite thing that was so important to them, one of their witnesses just walked in off the street. I don't think she was a very good witness. And the other two were fed to them by the federal grand jury probe. So what were they doing for 2 years with respect to their own experts? So I think the prosecution would be in a much stronger point at that point. But I think this DA's office has sent all the signals that we would love this thing to be over. So I think your idea of a potential plea would, and an attractive one, would be placed before Ms. Reed at that point.
All right, our experts are staying with us. When we come back, we're going to take you inside that jury room, inside the minds and the dynamics of the jury. Obviously, our cameras don't go in there. But what's that dynamic like? We'll bring in Susan Constantine, jury consultant.
I think that they're deliberating on evidence. I would assume that the hang-up is intent, because I don't know that I'm even told that she meant to do this, but she certainly did this.
As one of the anti-Karen Reed protesters at the courthouse today, seemingly to settling there on the manslaughter charge rather than the murder charge at the top of the account. But the jury has not agreed. Like, the 12 folks there have not agreed. They sent the note just before lunch today. Then the judge sent them back to deliberate. They told the judge they would work until 4:15. 4:15 came, no verdict. They're coming back Monday. So they're deadlocked. They're deadlocked. They said they were thoroughly gone through everything. They exhausted everything. So what's the dynamic? What's happening inside that jury room? Still with me, Rick Grundy, Peter Allikin, and joining us now, jury consultant and human behavior expert, Susan Constantine. Susan, thank you for joining us tonight. What are your thoughts about the dynamic? We don't know much about this jury. We know 6 men, 6 women. I don't know if that has anything to do with how this is breaking down in this case. Obviously, we don't know what the split is with the numbers, etc. But how about the human dynamic to compromise, to go from one side to the other side? What does it take? How does that happen inside of a jury room?
Well, it generally starts out with a majority. So that first ballot vote, how many of them find her guilty, and then how many are finding her not guilty? That first ballot vote, if they took one. Then we have all of the different personalities, right? And sometimes that can get a little sketchy. If you've ever watched inside a mock jury case and just watched the dynamics, it can get quite heated in there. You've got analyzers, you've got strong feelers, you have other people that are like silent jurors that really harbor a lot of internal thoughts, but they don't really express. So when you look at the entire dynamic, how do you bring them closer? Is really with a strong leader in the room to help them go through each piece of that evidence and look at it and then come up with a conclusion they think that is reasonable. So it's not about necessarily what's right or wrong. What can you live with? And see, that's what I think where they're getting tripped up on. The other thing is, I think is what's happening, we have analysis by paralysis. They're overthinking. I think that this weekend will be good for them. Get out of that courtroom. It's a weekend. They're flooded. Refresh, refocus, clear their heads, reset. They'll have much more clarity. Let's see what's going to happen on Monday.
Is it easier for someone sitting there to go from not guilty to guilty, or from guilty to not guilty?
Here's what I find is that they have to live with it. So what happens with jurors is they're thinking about how they perceive the information, they're relaying it to themselves. Can they actually live with that decision? And it's really more about them than it is even about the defendant. Can they live with that verdict?
Rick Grundy, something else that I've seen through the years of court TV, sometimes we have partial verdicts. They reach a verdict on one count, but maybe get caught up on another count. And we don't necessarily tell a jury that it's okay if they do that. They should let us know. We send them in there so blindly. What are your thoughts about this case and the potential for a partial verdict, Rick?
Well, if we really want to get into the dangerous area of reading the tea leaves, I thought about that with respect to this case, where you have so many options laid before you. If we want to think along the lines of there's a majority here, and what is the majority trying to get the minority to buy into? They have all these proposals. They could try and sell them on a manslaughter. They could try and sell them on the leaving the scene. They can go down this scale to try and get those that are not with them on that side. So they have a lot of options. Whereas if we look at it from the other side, if the majority, again, we don't know that, they're not evenly split, but if there is a majority trying to get a minority to go with them, and that majority is not guilty, the bargaining position has shrunk to virtually nothing, right?
Yeah,
so now it's like,
all or nothing.
No, she is not guilty, right? She's not guilty, get on board with us. And I agree with the expert, always do, but the idea, to me as a prosecutor, the fear of hung juries always struck immediately that it's easier to go from guilty to not guilty, just because you live with the idea that if there is any doubt, it's better that this person not go to jail. That's our system is based on. That's one of the premises. It's better to let a guilty person go free than an innocent person go to jail.
And Susan, do you think in the thought process at all, they're in that room with the defendant for 9 weeks, but they're also looking directly at the victim's family for 9 weeks, like day in and day out? And this was a tiny, tiny courtroom.
Yeah, there's a lot of emotions that go on there, and there's that familiarity when they look at Karen Reed. They create this bond with her. They've gotten to know her almost as if they've known her for a long time, but yet now on the other side of it, they have the guilt. You know, like I hate to have the defendant walk over this dead body and get off. So there's a lot of weight on their shoulders, and that's why when it really comes down to it, when you look at jury research, the research has found is that can they actually live with that verdict? It's a really interesting dynamic. Some can. They can clearly go, yep, she's guilty, not guilty. Some not so much. And I think that's where we're having the issue on those. It's the personalities that are happening and strong belief systems, maybe some guilt, fear. There's a lot of dynamics there, but I hope that there's someone this weekend will help them to kind of clear their head. I do have confidence that this jury can come back and decide on a verdict, but I think it's going to take some time just to clear their head, get de-flooded. Right now, they're over-flooded. They got so much in here, they got to get rid of it.
Maybe they watch the Sox this weekend. We're out of time for tonight. We're out of time for this week with you all, but thank you so much. Rick Grundy, Peter Ellikin, and Susan Constantine, thank you.